this is Paul Catalina. Every other time you've been on this show, I've been on vacation. So I'm very excited to talk to you.
Oh, damn. I should have scheduled it for September.
Yeah. But I'm very enthusiastic to ask you this question because I've asked a lot of reporters this, but never an attorney like you. Isn't valid business purpose what I, as a business owner, determine it to be, as long as it is within the laws of the state and the country that I live in?
Paul, I'm glad you and I are speaking about this very issue. I'm sorry we didn't get a chance to speak about it before, but you are 100% correct. And by the way, I'll take that even a step further. So is fair market value of compensation, right? And if an NIL collective wants to pay you, Paul, $2 million to attend XYZ university because you are a skilled athlete and your NIL value is through the roof, then that is the business judgment of the NIL collective. Could it pay you $1.5 million? Sure. Could it pay you $1 million? Sure. It has elected to pay you $2 million. So who's to say that in the exercise of business judgment, just like any other business, it shouldn't pay you what it believes you are valued at?
Well, I mean, because I can think of plenty of bad ideas that big companies have had that have cost them that seem invalid, but they weren't illegal. They were just dumb. So like, yeah, I could pay you $1 million and you could not live up to that as an athlete, but that just means I made a bad call and not that I'm breaking some sort of law.
And to go back to your original point, yes, there are NIL collectives that do in fact serve a valid business purpose. And what are those purposes? To raise awareness and attention to the program, to the university, to athletics as a whole. I mean, I represent, and I'm lucky to represent, the Penn State University Women's Volleyball Booster Club, which is a NIL collective that now supports and has supported for many, many years, long before NIL, the women's volleyball team at Penn State, the indeed national champions. There are valid business purposes for what it and other collectives do. Appearances, autograph signings, endorsements, and they even broker some endorsements. So to suggest that NIL collective serves zero valid business purposes, as the CSC tried to do, to me, that's an overreach.
So can we get to collective bargaining, Ryan? And is it something that eventually, it's like the four-letter word, or some don't want to say they want it, and some would, if in fact, would that end most of the problems? And why can't it be a part of college athletics?
Great question. And look, I'm not a labor law expert, but we do have labor lawyers here at the firm, and I've posed this question to them often. I mean, this is a topic of conversation here at the firm. And look, my understanding of this, and it's a very basic understanding, is that the National Labor Relations Act and the National Labor Relations Board applies only to a certain subset of what I'll call the universities, right? There are exceptions to the NLRA. So some schools would be covered by this. Other schools, such as those schools that have a religious base, like my alma mater, Seton Hall University, a Catholic institution, it wouldn't apply to Seton Hall and some other universities. Private universities, public universities, sure. But there are so many colleges and universities in B1 that I think a broad stroke across the board, that now suddenly we have a collective bargaining agreement among all member institutions across the country in D1. That may be hard to implement, particularly because I said, if the NLRA does and does not apply to certain schools, I think it might have to be on a conference by conference basis. But look, something needs to be done. And I say this from the athlete perspective, right? I mean, I've had the opportunity to represent schools. I've had the opportunity to represent college athletes, and I've obviously had the opportunity to represent NIL collectives in this space. And I come at this from the perspective of often the athlete. And as we've seen over the last week or two with President Trump's executive order, with the introduction of the SCORE Act in Congress, the executive order, the SCORE Act, this legislation is to me appears to be drafted in favor of the NCAA, in favor of the member institutions, and look, certainly because they have a pretty heavy lobby. For collective bargaining, I mean, we have this in the NBA. I'm an NBA agent, right? So we have a collective bargaining agreement that addresses issues between management and the players. There must be something to that effect across college athletics. The athletes need a seat at the table. They frankly needed a seat at the table for purposes of this executive order. They needed a seat at the table for purposes of the introduction of the SCORE Act, which I don't see. Now, I know there have been a number of hearings before Congress, and some athletes have attended, but you can't tell me that, particularly with the executive order, that Coach Saban didn't have a hand in drafting this. We know that he obviously is very close with the president and has been appointed to what we thought was going to be a committee in charge of college athletics. But look, something needs to be done in terms of collective bargaining, in terms of protecting the athletes and giving the athletes a real seat at the table.
One of the things that confuses me about at least the early version of the SCORE Act, Ryan, is that the state laws thing is a very valid point. Look, they need to figure out a way, to wrangle in why it's different. Look, if you're an NBA agent, if you're telling a guy, okay, we've got this offer from Brooklyn, we got this offer from Orlando, but the rules in Florida and New York for professional athletes outside of taxation are completely wild and different. Yeah, they need to rein that in, but it seems like it's also trying to roll back a lot of the court cases that they lost, which to me would then get them more in court. Is now we're not even just suing the NCAA. Now people are going to be suing Congress and all these other things or suing over this law because it rolls back things that people have already ruled on.
Yeah, and you hit the nail on the head there. Look, the SCORE Act, among other things, tries to grant an antitrust exemption to the NCAA and member institutions so that they don't have to face countless antitrust lawsuits as they have faced over the last 4 or 5 years. That's a problem. And if you noted in researching the SCORE Act and its proposed provisions, you would also see that literally every major sports players association has come out again granting antitrust exemption to college athletics and to the NCAA, the NFLPA, the NHLPA, MLS, Major League Soccer Players Association, my own NBA Players Association, and most notably, Major League Baseball Players Association, which coincidentally is the only professional sport that has been granted antitrust exemption. So even MLB came out, at least the Players Association, and said, no, not a good idea. And why isn't it a good idea? Because it effectively provides the green light for the NCAA, the member institutions, to collude against the college athletes, which arguably they've been doing for decades.
Yeah. Yeah, no doubt about it. Ryan, there's the